Morning. We're just waiting for people to join. We'll start in a sec. Good morning. If you just joined, we'll start in a moment. We're just waiting for some others to join. Just give it a few more moments and then we'll make a start. Okay, I think that's long enough. We'll make a start because we've got a lot to get through. So good morning and welcome to this webinar. We've not done one for a while, since June, so hope you had a good summer. Today, the topic, we're going to be doing a sort of eclectic mix, looking back on some cases that happened in recent times, looking forward at some of the legislation that's planned, and we're going to be an hour. And I'm joined by Keith Potter, my colleague in the Employment Department, and we're going to both do sort of 2 parts each, so we go back and forth a bit, and then we're going to have hopefully some time at the end for some questions. So if you've got any questions, pop them in the box down the bottom, and we'll try and deal with them. Now, we are recording this, but don't worry, we'll switch off the recording during the question bit at the end. So I'm going to kick off with some COVID cases in a moment, and then I'll pass over to Keith to deal with some non-COVID cases. But anyway, so let's get on with this then. Now I'm going to clatter through these a bit because there's quite a few of them, so sorry about that. I hope I don't miss out anything important. But on the COVID cases, we'll talk about Section 100 of the Employment Rights Act, because this is something that previously didn't come up much, but really came into its own during the pandemic. Without wanting to get too technical, with Section 100 on the slide there, I've set out the basic provisions there, so you can see where it applies, where it makes a dismissal automatically unfair. And what's important to remember is this is a day one right, so normally you'll know you need 2 years service to bring an unfair dismissal claim. If you can bring it under this section, it doesn't matter about service, as we'll see in some of the cases. So on the slide there, it tells you the kind of circumstances where it applies. So let's just look at those quickly. So where an employee brings to the employer's attention by reasonable means circumstances of danger connected to the workplace. This is a bit paraphrased, but you get the gist of what the section's saying. Or where an employee leaves or avoids the workplace because of imminent danger there, or because they take appropriate steps to protect themselves or others because of imminent danger at the workplace. So if they've been dismissed for any of those reasons, it's automatically unfair. We go to the next slide. So first of all, the first case, Rendina and Royston Veterinary Centre. What happened here, Ms. Rendina was a vet or an assistant vet working for this employer. She'd only begun employment in January of last year, and then the pandemic hit, and she was very concerned about it, and there was multiple occasions where she was contacting the employer to express her concerns. And the practice director there was not very sympathetic, and in fact was very skeptical about COVID, and he kept saying it being overhyped by the media, and that Ms. Rendina was exaggerating and really she shouldn't tell him how to live his life. Anyway, what happened was in March, she kept raising concerns, and eventually she was dismissed by the employer. And she'd only been there less than 2 months, so she couldn't bring an ordinary unfair dismissal claim. So she brought a claim under this section, Section 100. And at tribunal, the employer tried to argue the reason why they dismissed her was because of client complaints and because of lateness, but the evidence showed there weren't any client complaints and only one instance of lateness when a train was late. So the tribunal found that probably the reason why she was dismissed was because of the concerns that she'd been raising over COVID. That section applied, and therefore that was an automatically unfair dismissal. Next case, Gibson and Lothian Leisure. In this one, Lothian Leisure owned a restaurant in which Mr. Gibson was a chef. And again, he'd worked for less than 2 years for this company. And when the pandemic hit, he was very concerned because his father was clinically vulnerable, so he was shielding. And they shut the restaurant during lockdown, but towards the end of lockdown, they asked Gibson to come in to help out. And he was worried about his father. So he raised that. And apparently they weren't taking any COVID safety measures at the restaurant. So he raised this and he was told basically, you need to shut up and get on with it. Anyway, in May, he got a text from Lothian Leisure saying, "You dismissed with immediate effect. We're reorganizing business and we're going to run in future on a smaller team." So he had less than 2 years service and he brought a claim under the section 100. And the Employment Tribunal found for him, they found that before he'd raised those safety concerns, he was a valued employee, but afterwards not. And that was the reason behind his dismissal. So that was found to be automatically unfair and he succeeded. Different situation in Rogers and Leeds laser cutting. Here, Mr. Rogers was a laser cutter working in a workplace which was a warehouse type arrangement, so a large working area and only about 5 employees at any one time, and they had taken COVID safety measures in there. But when the lockdown hit, he texted his boss and said, "Look, I'm a bit concerned. I've got a baby in my house and another child with sickle cell anemia. So I'm going to stay away until the lockdown eases." And he was dismissed and he brought a claim under this section, but he didn't succeed in that case. The tribunal heard evidence that he had, although he was concerned about COVID, he'd acted a bit strangely. He'd driven a friend to hospital when he was supposed to be self-isolating, and he'd worked in a pub for a short period all around this time. And as I said, that was a workplace where they had introduced COVID safety measures. So the tribunal weren't sympathetic to that claim and they rejected it. They found that the reason why he was staying away wasn't really because of the workplace. He had concerns about COVID generally, but that didn't make this an automatically unfair dismissal. So on the next slide, please. Akitatis and Fortuna Group. So Mr. Akitatis worked for this company that distributed PPE, and his job was to take deliveries and to enter data onto a computer. And this company introduced more cleaning when the pandemic happened, and it had other COVID safety measures in place. Now he asked to work from home, and the employer said, "No, that's not going to work because what you do can't be done from home. You take deliveries, and you can't do that from home." So that was turned down. He then got ill and stayed away, off sick, and he asked to be furloughed. And the employer said, "Well, no, there's work for you to do, and we're still trading, so we don't think it's appropriate to furlough you." Anyway, a few weeks went by, and he asked again to work from home and asked again to be furloughed, and it was turned down both occasions. And after a few weeks, they dismissed him, and they said, "You're you weren't supporting the company's policies or guidelines, and we're going to let you go. And he didn't have 2 years service, so he brought a claim under section 100 and he failed. The employment tribunal in that case found that the reason why he was dismissed was the employer found he was an awkward employee, not because of his desire to stay away from the workplace. Next one, Montanaro and Landsafe. Here, Mr. Montanaro was an IT engineer, and he only began his employment for this company in, I think it was January 2020, it might have been February, but he hadn't been there long when he was in Italy, in fact, and the pandemic broke there, and he was stuck there. And he contacted the employer and said, look, I can't travel at the moment because of the pandemic, but I can work remotely. I've got my computer, so send me instructions and tell me what you want to do. Anyway, he didn't receive anything back, except in due course he was summarily dismissed for taking unauthorized leave. And he brought a claim under this section, and you won't be surprised to learn that he succeeded. In Ham and ESL, Mr. Ham, again, very short service, less than 2 years employment. He was a cleaner, and he was asked to deliver some equipment to his manager, who was at home self-isolating with their daughter, both of whom had apparently COVID symptoms. And he was concerned about that. And he said, look, no, I'm not going to do that because I'm worried about my own safety. And he was dismissed. And he brought a claim under section 100, and that was held to be a valid claim, and he succeeded. If we go to the next slide, please. So moving away from section 100, now these are ordinary unfair dismissal claims. First one, Kubilius and Kent Foods. Mr. Kubilius was a driver for Kent Foods, and they had good documentation in place. They had a handbook that said you must take care for your health and safety and health and safety of others. They had a driver handbook which said you must follow clients' instructions regarding use of PPE. Anyway, his job entailed him having to visit a Tate & Lyle site on a regular basis. And Tate & Lyle had introduced in the pandemic a requirement for visitors to wear face masks. But Mr. Kubilius wasn't very happy about that and refused to wear a face mask. And he was challenged on a couple of occasions by Tate & Lyle employees who were worried about basically him spraying droplets onto their faces from his elevated position in the cab, in the lorry he was driving. And so they asked him to wear a face mask. He refused. He said, it's not a legal requirement, I'm not going to do it. Anyway, Tate & Lyle banned him from the site, and they reported this incident back to Kent Foods. And Kent Foods disciplined him, investigated this matter, and they summarily dismissed him at a disciplinary hearing, and he claimed that was an unfair dismissal. And the tribunal were not sympathetic to Mr. Kubilius. They held that the employer carried out a reasonable investigation and disciplinary process, and they acted reasonably in treating that as a fair reason to dismiss. So that claim failed. Then a couple of cases about furlough and slightly contrasting results. Now, last year, clients were asking us, can we dismiss for redundancy where we've got the opportunity to furlough? And we had to advise on that. And here's a couple of cases with results that show that it can be a bit of a lottery. So in Mandura against Loving Angels Care, this lady was dismissed for redundancy early in the pandemic when she could have been furloughed, but they didn't do that. So she brought a claim for unfair dismissal. And the tribunal in that case found that the dismissal was unfair because the employer hadn't given any reasons at all why it wouldn't consider furlough, even perhaps for a short time, to see if the situation changed. So it was unfair dismissal. Compare that to Hanley and Tatton Hill Aviation. In that case, Mr. Hanley was furloughed early on in the pandemic and then stayed on furlough for about 3 months, I think it was. And then they dismissed him for redundancy when they could have kept him on furlough. And he claimed unfair dismissal on that basis, but he failed. The tribunal found that different employers will take a different approach, but the existence of the furlough scheme in itself and the availability of that didn't make a redundancy dismissal unfair. Both were held to be fair redundancies, but you see a contrasting approach in the tribunals in both cases. Some other cases connected with furlough. So Bradbury and Cubone, this one's about holiday pay. And Ms. Bradbury was put on furlough. She was given a furlough agreement, which said furlough is expected to last for at least 3 weeks, and you must take any holiday during that furlough period. Anyway, she left work a few months later, and she wasn't paid for a holiday, which she claimed. So the question was, did that furlough agreement that said you've got to take holiday during the furlough act as a waiver or a release of any holiday pay claim? And it was held to be ineffective for that purpose. The furlough agreement needed to be a lot more precise about what holiday had to be taken, i.e. how much, and when it had to be taken to meet the rules under the working time regulations. So she was entitled to holiday pay that had accrued to termination, including for the furlough period. In Cade and Booth Walsh Automation, this is another interesting case about the application of the furlough scheme. Here, he went sick. His contract said you only get SSP only when you're sick. And he claimed unlawful deduction from wages on the basis that the company could have furloughed me here and paid me 80% pay. So that's an unlawful deduction from wages. And the tribunal had no time for that, basically. They said the issue is, what are you entitled to under the contract? And until you are actually furloughed by your employer and you accept being on furlough and you agree to it, then there's no variation in the contract. The contract still applies. You're only entitled to sick pay as per the contract. The existence of the furlough scheme didn't give you an automatic entitlement in that way. If we move to the next slide. A couple of cases where there was no furlough agreement in place and the effect of that. So in Luff and Tarks of Scotland, here Ms. Luff was furloughed without her consent, and she wasn't given a furlough agreement, and she was paid 80% of her pay, and she later claimed the shortfall in her wages, and the tribunal upheld her claim and she won there. Whilst she was on furlough, she had to agree to that for there to be a variation in her pay entitlement. So she was still entitled to her full pay with no signed furlough agreement agreeing to a lower rate of pay. But in Viner and Sampson, the situation there is different. There, Viner was a beauty therapist working for Sampson's salon. Sampson said, I'm going to furlough you, and Viner, just through the news really, thought, well, that means I'm going to be not required to work and I'm going to get 80% of pay, but there was no furlough agreement. Anyway, Sampson in the meantime is advised that you can't claim under the coronavirus job retention scheme for Viner. And a few months later, Viner came back to work, but she left shortly after. She hadn't received any furlough pay, so she brought a claim for the furlough pay. And the tribunal held for her. It didn't matter that there was no furlough agreement. There had been an implied variation in her contract, and she was entitled to the furlough pay. Finally, before I hand over to Keith, the same case again, Luff and Tarks of Scotland, I just mentioned there. Here is a whistleblowing claim as well here, because there was a meeting in this case where Luff and colleagues met with the CEO, Mr. Singh, of this company, and they said various things to him, including that the company weren't following the government COVID guidance, that they were being asked to work whilst the company were claiming for them under the the coronavirus job retention scheme, and that they weren't providing a safe workplace. And as Luff was a cancer patient, she was covered under the Equality Act. And the CEO, Mr. Singh, was upset apparently by these comments, and later on, Ms. Luff was dismissed, and she brought various claims against the company, and the tribunal held that those comments were all protected disclosures, and therefore her claim for unfair dismissal for whistleblowing succeeded, and she obtained considerable compensation, including £12,500 for injury to feelings. Okay, that's the end of the COVID cases. Now I'm going to pass over to Keith, who's going to be looking at some different cases.
Thanks very much, David. Hello, I'm going to start by looking at a case involving a complaint of racial discrimination. This case of Ali UK Limited and Galen. The importance of the case lies in the fact that it illustrates the difficulty that employers can face if they try to rely on what is often referred to as the statutory defence in discrimination claims, which says under the Equality Act that it's a defence for the employer to show that it took all reasonable steps to prevent employees from either committing a particular discriminatory act or committing acts of a discriminatory kind in general. Now, the facts of this case were that the employee, Mr. Galen, described himself as being of Indian origin. He was told that he was going to be dismissed after a fairly short period of service because the employer wasn't happy with his performance. At about the same time as he was told that, he complained that he'd been subject to harassment by a fellow employee, harassment on the grounds of his race, in that racist comments had been made to him. I mean, this, it appears, had occurred relatively recently, though he hadn't reported the matter immediately. When the employer was told about this, they did carry out an investigation. They established that the fellow employee had indeed made racist comments, and they warned the fellow employee and ordered him to undertake further training. Now, when Mr. Galen's employment ended, he brought a claim under the Equality Act, a claim that he'd been the victim of direct discrimination on grounds of race. Now, the employer tried to rely upon the defence, the statutory defence, that it had taken all reasonable steps to prevent comments of a racial nature from being made. Now, the tribunal rejected that because, I mean, their principal view of the employer's defence was that the training, that there had previously been training provided, but it had been delivered 2 years or more before the events in question, and it was stale, and as a consequence, it was ineffective. And they reached that conclusion for various reasons. I mean, firstly, there was, the central fact that the fellow employee had made racist comments to Mr. Galen. There was also the fact that when he was disciplined about it during the internal disciplinary investigation, he said that what he was doing, he thought it was no more than banter and was acceptable for that reason. There was also the fact that a colleague who apparently heard the racist comment did not report it to management. And when two managers were subsequently informed about the racist remarks, they didn't take any action either. And in the view of the tribunal, this showed that whatever training had previously been provided, it was no longer effective. It wasn't having any effect on the attitudes and mindset of the people within this workplace. So the point is that, yes, it's a good idea to provide training of this kind. Indeed, it's essential. But it's equally important if you're going to use the training as a possible defence to a discrimination claim, it's equally important to provide refresher training at fairly regular intervals, just to remind people of what the legislation requires, and so that they keep those requirements firmly in mind. Next slide, please. I wanted to talk now about a recent case involving gender reassignment. I mean, this has been a topic in the press over the last 12 months or more, which it's been the subject of increasingly heated debate, with strongly held views on each side, if you like. I mean, the starting point is the Gender Recognition Act back in 2004, which allowed a trans person to obtain a gender recognition certificate and to be legally recognised as a person of the opposite sex. And that led to legislation which made it unlawful to discriminate or harass somebody on grounds of gender reassignment. The case that I'm referring to, Taylor and Jaguar Land Rover, it is just an employment tribunal decision. So to that extent, it's not authoritative or binding on any other tribunal or any other court. It involved a very difficult situation for Jaguar Land Rover. In the claimant was a man who had previously been known as a gay man, and had worked for Jaguar Land Rover for 18 years. And it appears from the tribunal decision that he'd had no problems with the fact that he was gay over the whole of that period. Indeed, there was no suggestion that within Jaguar Land Rover generally there were problems with discrimination on grounds of sexual orientation, or indeed any other form of discrimination. There was no suggestion that it was a widespread problem. The problem for this particular individual arose when, after we were living as a gay man for the past 18 years, or working within Jaguar Land Rover for the past 18 years as a gay man, he told managers that he regarded himself as being transgender or gender fluid, as he put it, or non-binary, and that he was intending to transition from the male to the female gender. Now, that manifested itself in his coming to work on 2 days a week, dressed as a woman. He complained that he was harassed by various colleagues when he was dressed as a woman, and that there were comments made to him on the lines that people were referring to him as it rather than him or her. He was asked if his clothing was his Halloween get-up. People said things like, they commented on his having nice legs. They said things like they could see the top half and the bottom half of him, and the top half and the bottom half didn't match, and comments like that. Now, he was also within Jaguar Land Rover. He was heavily involved in trying to develop lesbian, gay, and bisexual and transition awareness within the company. Jaguar Land Rover, it appears, were happy for him to be involved in trying to achieve that, to improve greater awareness and to make it easier than it might otherwise have been for transgender people to feel comfortable with Jaguar Land Rover. It appears, certainly from the Employment Tribunal decision, that some progress was made, but that he wasn't happy with it. And it's difficult to avoid getting the impression that whatever Jaguar Land Rover did, whatever progress they tried to make, that he was going to find fault with it. Even the most inappropriate comments that were made to him, or inappropriate language that was used, he would take exception to it. It did make life extremely difficult indeed for the employer. Eventually, after about a year, after a year of his dressing in female mode on 2 days a week, he resigned. He said he couldn't stand any more of the comments that were being made to him from time to time. And he was unhappy about the progress with the development of LGBT awareness within the company. But then, having said that, within about a month after giving notice of resignation, he said he wanted to withdraw it. And the company at that stage obviously thought about the matter and appeared to have concluded that enough was enough, and that there was no way forward with this individual. There was nothing more that they felt that they could do to satisfy his requirements. And a huge amount of time had clearly been spent in meetings with him. So the claim, his claim succeeded. Compensation was agreed between the parties and awarded by the tribunal in the sum of £180,000. And the company was also awarded to contribute 25% of his legal costs. Now, if we can move on to the next slide, please, to look at some of the issues, and sorry, onto the next slide as well, please. Some of the issues that arise from gender reassignment, which Jaguar Land Rover tried to grapple with in the context of this case. I mean, firstly, that there's the need to consult the individual and to discuss with the individual who needs to know, and how, when, and what will people be told about the employee's estate, and so that people are aware of what the individual proposes to do by way of dress, and so they can understand how other employees might be expected to react to what for most people would be a rather unusual state of affairs. Employers should certainly be open when an employee is transitioning to try to ensure as far as possible that colleagues behave sensitively. And equally important to consult with others who may be affected by steps that are taken in relation to the trans person. Now, that is particularly important in the context of toilet use, whether the person should use the male or the female toilets, which was a particularly troublesome issue in the case of Mr. Taylor. I mean, he was, I should say at the time, he was Mr. Taylor, but he subsequently became Ms. Taylor, and that apparently is what he is, what he is now. I'm going to talk in a little more detail in a moment about the toilet issues, but it's important to bear in mind that if, for example, the individual is told, well, you can use whichever toilet, whether it's the men's or the women's toilet, whichever you feel appropriate on the particular day concerned. It's the case that particularly if the individual is minded to use the women's toilets, that may well give serious offence to women who feel that the women's toilets ought to be a safe space for them, and that they should not have to share them with a person who is biologically a man. Now that is it is a view that needs to be respected. And indeed, it's obvious from the tribunal's decision, Mr. Taylor's case, that he himself recognised that it was far from being a straightforward matter whether he should be permitted to use the women's toilets if he felt minded to do so. There's the question of an employer's policies on equality of opportunity and diversity and that sort of thing. And it's important to consider whether they might need to be updated to reflect gender reassignment issues. It's also important to avoid well-meaning steps, such as requiring all staff to disclose their pronoun, whether they would like to be referred to as he or she, because it's possible that this could offend the beliefs of some other staff and other transgender individuals who haven't made their status known to fellow employees. If we could go on to the next slide, please. It's important to remember it's a criminal offence under the Gender Recognition Act to disclose the gender history of someone who has a gender recognition certificate. I mean, it's a strict liability offence. So, making a disclosure with the best of intentions isn't a defence. And so it is important to educate staff who know of a trans person's gender history to avoid any disclosure of information that the trans employee is not expressly agreed to. Next slide, please. You mentioned just now this issue of toilet provision. The ACAS view is that a person can choose which toilet to use, but I think there are serious questions about whether that is right. As I said, Taylor itself, judging from what the tribunal decision says, recognised that there were difficulties about that, and he does not seem to have asserted the right to do what is expressed in the ACAS view. We got the workplace health and safety and welfare regulations of 1992 requiring employers to provide single-sex toilet and washing facilities. And obviously, some employers may do that, may do what is required by the regulations, but at the same time designate some, but not all single-sex facilities as unisex. And that apparently is what Jaguar Land Rover tried to do. But you have to bear in mind that your Jaguar Land Rover at the time and still has some 40,000 employees. And Mr. Taylor did not work exclusively in one particular area. And so, toilet use became one of the many, many issues that caused him to be dissatisfied with the response that he received from Jaguar Land Rover. Reading the tribunal's decision, it is quite difficult to, it's not difficult to get the impression that whatever Jaguar Land Rover did, Mr. Taylor would have found fault with. I'm going to hand back to David now for him to continue.
Okay, I'm going to look at some other recent developments. So in February, the government's consultation on the reform of law relating to restrictive covenants in employment contracts closed. So restrictive covenants in contracts, they're things like non-compete clauses preventing employees from approaching the company's customers, that kind of thing. This is an area that's been regulated just by case law for years and years. So the government showed an interest in legislating on this. We await their response, which has been delayed because of the pandemic. And we'll find out soon enough whether they are actually going to introduce legislation on that question. In April, we had the usual limits and rates increase, various things going up that time of year, and I put a few details on the slide there. The weekly pay cap for working out redundancy pay, for example, and the limit on the compensatory reward for unfair dismissal. And you may know that the IR35 rules changed also in April, shifting the burden compliance from a worker's personal service company onto the client company if it's a medium or large organisation that they work for. And then in May, the protection that existed previously just for employees, where they claim detriment because of health and safety reasons, was extended to workers. And Keith will be talking about workers in a moment. And in July 2021, the government published its response on the consultation they did on sexual harassment. This is another area that, of course, we heard a lot about in recent times, but then got parked because of the pandemic. And anyway, the government's response, they said they were going to introduce a statutory duty on employers to prevent sexual harassment occurring in the workplace, which was an interesting development, and we'll have to see in the fullness of time what that looks like and how it will change the law in that area. Obviously, employers are already under an obligation, in theory, to prevent sexual harassment in the workplace. So we'll have to see how this duty expands that. And of course, in the end of September, you'll know that the coronavirus job retention scheme finally came to an end. On the next slide, just some things that are coming up. So in September, the government responded on their consultation about introducing a right for, it's an unpaid right for leave for carers. I'll mention that in the context of the employment bill in a moment. And then later this month, the legal requirement for care home staff to be fully vaccinated unless they have a medical exemption comes into force. And on 1st of December, the government consultation on making flexible working the default closes. And again, I'll mention that on the next slide, because the next slide talks about the employment bill. This was talked about first in the Queen's speech in December 2019, and then of course we had the pandemic, and that really did get delayed, because even in the last Queen's speech in May, it wasn't mentioned, but the government have since said they're still going to bring in this employment bill. And I put on the slide there some of the things that it's expected to deal with. First of all, a single enforcement body, and that's going to deal with various things like regulating statutory sick pay, looking at holiday pay rights for vulnerable workers, modern slavery, and some other areas. So that'll be a new body dealing with those issues. Tips for workers in the leisure sector. You may not know this, but at the moment, they're not necessarily entitled legally to get the tips that people leave for them, and that's something that the government have been talking about legislating for a while, and that's something they're going to bring in this bill. The right to request a more predictable contract. This is like 0 hours workers, really, people that have got a unsettled working pattern. The idea is that there's going to be a right after, I think, 6 months service to request a more predictable contract. So that's coming in. Extending redundancy protection to pregnant employees. What this is about, you may be aware that if an employer wants to make a woman who's on maternity leave redundant, they must first offer any suitable vacancy that they have in priority for that woman on maternity leave over anybody else. And if they don't, there's a claim under the regulations. And the change then is to extend that protection so it will kick in not just during maternity leave, it will kick in at the point a woman notifies pregnancy to the employer, and then will extend to 6 months after maternity leave ends. So it extends that right. And then a few other bits there. So leave and pay for neonatal care, that's going to be a new right that's going to come in. I think it's 2 weeks leave. I can't remember, but that's a completely new right. Then I mentioned the leave for carers. That's coming in too. And then finally, on flexible working. So the government have confirmed they're not going to introduce a right to work from home, but they do want to develop the flexible working right. Now, you'll know that you've got to be employed for 6 months before you've got the right to request flexible working. So the main change is that they're going to make that a day one right. So a brand new employee can ask to work flexibly. But apart from that, the system should stay pretty much the same with a few tweaks, but it's going to continue with this sort of conversation between employee and employer about changing the working arrangements with a right of appeal, and the whole thing's going to be done in 3 months. So we await the employment bill dealing with all those areas. Now we've got a bit of time, Keith, and then we want to try and do some questions at the end. So I'll hand back to Keith now.
Yeah, just quickly, the statements of terms and conditions that employers have to provide, or traditionally or historically, they only had to provide them to people who were employees. Now, the law changed at the start of April last year, so the obligation now applies to people who are workers as well as those who are employees. I'll talk in a moment about who falls into the category of workers. The other change in this area is that this is now a day one right, right at the start of employment. A statement of terms and conditions has to be provided to the employee or worker, and not within the first 2 months of employment, as was previously the case. The further change is that extra information is now required as well, on top of the existing items that are referred to in Section 1 of the Employment Rights Act. We've got the employer has to say the days of the week the employee is required to work, whether the days or hours are variable, whether there's any additional or remuneration benefits will be available, if there's a probationary period, how long it is, and what conditions it might be subject to. And they also have to give details of any training which the employee is required to complete, and also any training which the employer will not pay for. So a number of additional things have to be covered. When the employer is thinking about how these extra, or how all of the terms and conditions, including the extra one, should be set out, it is important to think whether the terms should be contractual or non-contractual. And that's particularly important in the case of additional remuneration or benefits. It's perfectly possible for additional remuneration to be a matter for discretion for the employer and not a contractual right. That could be, for example, under a bonus scheme, which in many cases will be discretionary and not a matter that the employee is entitled to as of right. Employers will need to think now, if they have people who may fall in the category of workers, the employer will need to think about how to differentiate between the statements for employees and those who are workers. And the reason for that is that the workers will potentially have more limited statutory rights. It's worth just spending a moment just looking at the statutory definition of a worker. An individual works under a contract, which is not an employment contract, under which the individual undertakes to provide personal work, to do work or provide services personally for the other party to the contract. But the other party to the contract mustn't be a customer or client of any professional business carried on by the individual. So just thinking about who might fall into this category. Go on to the next slide, please. I mean, the most obvious example, perhaps the most well-known example, are people like the Uber drivers, and in more recent cases, it's been motorcycle couriers and people like that. They're people who are not subject to all of the controls and routines that are normally associated with employment, but at the same time are not in business on their own account, because typically they are working exclusively for example, Uber or a motorcycle courier company. They're not like people in business on their own account who would typically be working for a number of different clients. Just thinking about the rights with all the statutory rights that apply to workers, they are limited, and the principal ones are the right to paid statutory annual leave. That's the statutory amount, the 28 days under the working time regulations. They're also entitled to the employer's pension contribution under the auto-enrolment arrangements. They may be entitled to SSP depending on the level of earnings, and they're also entitled to an itemised pay statement and the national minimum wage. If we go on to the next slide, please. Finally, I just wanted to say something briefly about sleep-in shifts and the amount that people are entitled to be paid for sleep-in shifts. It's been an area of some uncertainty and debate for quite a long time now as a result of a case some 20 years ago. The matter in the case that I referred to on the slide there, the Royal Mencap Society and Tomlinson Blake, the case went right up to the Supreme Court, the High Court in the UK. It went up to that court for them to consider this issue, and they looked at the starting point was the Low Pay Commission recommendations some 20 years ago, which said that sleep-in workers should receive an allowance agreed with the employer, but not the national minimum wage, unless the individual was actually awake during the shift for the purposes of working. And the Supreme Court took the view that was indeed the intention of the relevant legislation here under the National Minimum Wage Act. They said that if the only requirement for the person doing the sleep-in shift is to respond to emergency calls, then the worker's time over the sleep-in shift as a whole will not be included so as to give the person an entitlement to be paid the national minimum wage. The person will only have that right if the person is woken up by an emergency call and answers it and does something in relation to that. That time, the person is entitled to be paid for what they're doing, but for the rest of the time, when they're going to be asleep for most of the time and on most days, they will be entitled to the allowance agreed with the employer, but not the national minimum wage rate. Thank you. I think we do have some time for questions now. So, David, perhaps you can give an indication of whether